Hi, good morning, folks. So, we were discussing about the various cases which have happened under the Posh Act, and we were discussing it one by one. We discussed Vishakha guidelines, we discussed some of the other cases which happened in the past, and today I would like to discuss a case which happened as recent as 2019. So this was Vinay Kumar Rai versus Union of India. Okay, and this happened in 2019, so just before pandemic, which means. And again, this has happened somewhere in the northeastern region of India. So here, the Tripura High Court it observed that express mentioning of instances of sexual harassment is not mandatory in the victim's complaint under Posh Act. So what happens is, lot of times the victim has filed a complaint, but he or she, and specifically because Posh is as of now covering only women, I would like to say that she would not be in a position to write the complaint in a most efficient manner. So there can be ups and downs in the way she has filed the complaint, and definitely her lacuna in filing the complaint or in the format of the complaint should not be taken against her. So this was what was held under this case. So what happened is the court pointed out that the definition of sexual harassment as provided under section 2N of the Posh Act, it is not a exhaustive definition at all, but rather it is an inclusive one, which means that in case the victim is able to prove that something like that has happened with her, she has to be heard in complete sense, as in a complete picture should be taken from her. The acts or behaviors as mentioned under section 2N of Posh Act was to ensure that acts of sexual harassment were done directly or by implication and are included within its ambit. So even if certain acts which are not happening directly, but it is by implication, as in it can be implied that there is sexual harassment, even such cases will be covered under this. It was then observed that given the broad ambit of the definition and express intention, an express instance of sexual harassment in the complaint was not necessary. During the inquiry by the ICC, it was revealed that petitioner had called the complainant to his chamber post the working hours and made remarks on her looks and tried putting his hand around her. The court concluded it was an unwelcoming act to be interpreted as sexual harassment within the meaning of section 2N. So what broadly we see here is 2N is very exhaustive, wherein even a implied sexual harassment act will also get covered under it. It need not be necessary that something gross has happened against the victim. So I hope highlighting this case helps you in understanding the act better. Thank you, and do subscribe to my channel. Thank you very much.